Chapter 11, Local Government and Decentralization. Part 1, Principles of Decentralized Local Government. Principles of Decentralized Government. 201. The principles of decentralized government are A. To promote democratic and accountable exercise of power. B. To foster national unity by recognizing diversity. C. To give powers of self-governance to the people to be exercised through their respective local government authorities. D. To recognize the rights of communities to manage their own affairs and to further their development. E. To protect and promote the interests of marginalized groups and communities. F. To promote social and economic development and the provision of proximate, easily accessible services throughout the Gambia. G. To ensure equitable sharing of national and local resources throughout the Gambia. H. To facilitate the decentralization of state organs, their functions and services to the administrative areas of the Gambia. I. To enhance checks and balances and the separation of powers. System of local government. 202. 1. A local government shall be based on a council which shall be the highest political authority for local governance within its area of jurisdiction and which shall have legislative and executive powers to be exercised in accordance with this Constitution and an Act of the National Assembly. 2. Local government authorities established under this Constitution shall reflect the following features. A. Local governments shall be based on democratic principles and the separation of powers. B. Local government authorities shall have reliable sources of revenue to enable them to govern and deliver services effectively. C. No more than 2/3 of the members of representative bodies in each local government authority shall be of the same gender. And D. A minimum of 10% of the members of representative bodies in the local government shall be youths. 3. A person shall not be a member of a local government authority unless that person is a citizen of the Gambia. Part 2. Establishment and composition of local government authorities. Establishment and composition of local government authorities. 203. 1. An Act of the National Assembly shall provide for the establishment of city councils, municipalities, and area council, in brackets, which are together referred to as local government authorities, and the general districts in which each shall have jurisdiction. 2. The geographical boundaries of each local government authority shall be determined by the Independent Boundaries and Electoral Commission. 3. Every local government authority shall comprise such number of members as may be specified in an Act of the National Assembly. Functions and powers of local government authorities. 204. 1. An Act of the National Assembly shall make provision for the functions, powers, and duties of local government authorities, including provision for A. The infrastructure and development of the area within the authority's jurisdiction. B. The encouragement of economic activities. C. The participation of the people in the development and administration of the area. D. The essential and other services to be provided by the authority. E. The raising of revenue. F. The management, control, and oversight of the authority's finances and facilitate the auditing of its accounts by the Auditor-General. G. The making of bylaws in accordance with powers conferred by an Act of the National Assembly. H. the preservation of the environment. I, the promotion of Gambian traditions and culture. And J, the control of financial and other resources allocated by the central government. 2. It shall be an object of the local government system that so far as possible issues of local policy and administration shall be decided at a local level, and that local government authorities shall cooperate with the central government in adopting a policy of decentralization in accordance with this Constitution. 3. No person or authority shall interfere with or compromise a local government authority's exercise of its powers or ability or right to perform its function under this Constitution or an Act of the National Assembly. Loans and grants. 205. 1. Subject to the provision of this Constitution and with the approval of the government, a local government authority, for the carrying out of its functions and services, borrow money or accept and use any grant or assistance as the National Assembly may prescribe. 2. An Act of the National Assembly shall provide for the conditions under which a local government authority may exercise the power to borrow for the purpose of carrying out its functions. Part 3. Election and terms and conditions of appointments of local government authorities. Election of members of local government authorities. 206. 1. A mayor, mayoress, and chairperson of a local government authority shall be elected by universal adult suffrage of all eligible voters in the local government area. 2. A councillor shall be elected by universal adult suffrage of all eligible voters in a ward. 3. No person shall be eligible to be elected under subsections 1 and 2 unless he or she is of high moral character and proven integrity. 4. Persons who are elected in accordance with subsections 1 and 2 shall A. act in a manner that is consistent with their duties and responsibilities, and B. be collectively and individually accountable to the people in their wards and local government areas for the performance of their functions. 5. An Act of the National Assembly shall provide for the qualifications and disqualifications for the office of councillor, mayor, mayoress, and chairperson of a local government authority. Term of local government authorities. 207. Local government elections shall be held every 5 years. Financial autonomy and accountability. 208. 1. Local government authorities shall have autonomy over their financial and development planning matters in relation to the areas they have jurisdiction over and with respect to the discharge of their functions generally. 2. Local government authorities shall, in their financial and development planning matters and in the discharge of their functions as referred to in subsection 1, take into account the policies and priorities of the government with regard to the development of the country. 3. For purposes of development in any local government area, a local government authority shall prepare comprehensive and integrated development plans which shall be published. 4. An Act of the National Assembly shall make provision A. Requiring local government authorities to draw up a comprehensive list of all their revenue sources and to maintain data and total potential collectible revenues. B. Prescribing financial control and accountability measures for compliance by all local government authorities. And C. imposing regular audit requirements and procedures for local government authorities. Part 6. Other offices of local government authorities, in brackets, Seyfos and Alkalos, institution and election or appointment of Seyfo and Alkalo. 209. 1. The institution of the office of Seyfo and Alkalo as recognized and established by customs and usages and the non-abolition of such offices is hereby guaranteed and preserved. 2. A Seyfo shall be elected by universal adult suffrage of all registered voters in the district on a non-partisan basis. 3. An Alkalo shall be appointed by the minister responsible for local government in accordance with traditional lines of inheritance. Prohibition from participation in partisan politics. 210. Every Seyfo and Alkalo is responsible for maintaining social stability and cohesion in his or her community and shall not participate in active party politics or affiliate with any political party or express any political views in the performance of his or her duties. Tenure, qualifications, and disqualifications of Seyfos and Alkalos. 211. 1. Subject to subsection 2, a Seyfo or an Alkalo who is elected or appointed shall hold office for life unless he or she resigns. 2. A Seyfo or an Alkalo may only be removed from office on any of the following grounds. A. Ill health arising from infirmity of body or mind. B. Misconduct. Or C. Misbehavior. 3. An act of the National Assembly shall make provision for the qualifications, disqualifications, powers, and functions of Seyfos and Alkalos. Chapter 12. Independent Institutions. Part 1. Establishment of independent institutions and offices. Establishment. 212. 1. There is hereby established the following independent institutions and offices, which shall be institutions and offices in the public service. A. National Human Rights Commission. B. Anti-Corruption Commission. C. Ombudsperson. D. Auditor-General. And E. Central Bank of the Gambia. 2. The provisions of this chapter apply to the Independent Boundaries and Electoral Commission established under Chapter 7 as the context requires, and insofar as the provisions of this chapter are not provided for in Chapter 7. 3. The reference in this chapter to member refers to the persons constituted under the independent institutions and offices mentioned in parts 2 to 6, including, as the context requires, the Independent Boundaries and Electoral Commission. Objects and funding of independent institutions and offices. 213. 1. Every independent institution and office derives its authority from the sovereignty of the people and shall, in the performance of its duties, be guided by integrity, transparency, and accountability, including the following. A. Protecting the sovereignty of the people. B. Ensuring that all relevant institutions observe the values and principles enshrined in this Constitution. C. Ensuring strong governance standards and practices. And D. Promoting the objects and principles of this Constitution and any act of the National Assembly applicable to it. 2. The independent institutions and holders of office shall not, in the performance of their functions, be subject to the direction or control of any other person or authority. 3. Save in relation to the central bank, the National Assembly shall allocate adequate funds to enable each independent institution and office to perform its functions, and the budget of each independent institution and office shall A. be a separate vote, and B. be charged on the Consolidated Revenue Fund. Appointments and term of office 214(1). Each independent institution or office shall be constituted as prescribed in this Constitution. 2. The chairperson, each member of an independent institution, and the holder of an independent office as provided in this chapter shall be appointed by the President, subject to the confirmation by the National Assembly. 3. To be appointed, a person shall have the specific qualifications required by this Constitution or an act of the National Assembly, or both, where applicable. 4. Appointments to independent institutions and offices shall take into account the national values mentioned in Chapter 2 and the principle that the composition of the independent institutions and offices taken as a whole shall reflect gender diversity. 5. Save in relation to the central bank, the remuneration and benefits payable to or in respect of a member of an independent institution or the holder of an independent office shall be a charge on the Consolidated Revenue Fund. 6. The remuneration and benefits payable to or in respect of an independent institution or the holder of an independent office shall not be varied to the disadvantage of the member. 7. A member of an independent institution or the holder of an independent office is not liable for anything done in good faith in the performance of a function of his or her office. 8. The chairperson and vice chairperson, where applicable, of an independent institution or office shall not be of the same gender. Qualifications and disqualifications 215(1). A person qualifies to be appointed as a member of an independent institution or a holder of an independent office if he or she A. is a citizen of the Gambia, B. has a minimum of a university degree or an equivalent qualification in a relevant field, and such other qualifications as may be prescribed by an act of the National Assembly. C. Declares his or her assets and liabilities. D. Has paid his or her taxes or has made arrangements satisfactory to the appropriate tax authority for the payment of the taxes. And E. Is of high moral character and proven integrity and possesses considerable experience and demonstrated competence in the conduct of public affairs. 2. A person shall not qualify to be appointed as a member of an independent institution or a holder of an independent office if he or she has been declared to be of unsound mind. B. Is a member of the National Assembly or any other elective office. C. Is or has at any time during the 5 years immediately preceding his or her appointment been nominated as a candidate for election as a member of the National Assembly or any other political office. D. Is or has at any time during such period of 5 years been the holder of any office in any organization that sponsors or otherwise supports or has at any time sponsored or otherwise supported a candidate for election as a member of the National Assembly or of any local government authority, or he or she has actively identified himself or herself with any such organization. E. Holds another office in the public service. F. has, except in the case of the central bank and the Auditor-General, held office as a staff of the Commission within a period of 2 years preceding his or her appointment, or G, has been convicted in any country of any offense for which he or she has been sentenced to a term of imprisonment of 6 months or more and has not received a pardon. 3. In addition to the qualifications set out in subsection 1, the chairperson of the Independent Boundaries and Electoral Commission, National Human Rights Commission, and Anti-Corruption Commission shall be a person qualified to be appointed a judge of the Supreme Court, a retired judge, or a person with other relevant qualifications with proven integrity, experience, and demonstrated competence. Removal from office. 216(1). The President may remove from office a member of an independent institution or a holder of an independent office, A, for inability to perform the functions of his or her office, whether arising from infirmity of body or mind or from any other cause. B, if any circumstance arise which would have disqualified him or her from appointment to the office. C, for misbehavior. D, for misconduct, whether in the performance of the members' or office holders' functions or otherwise. E, on account of being suspended or disqualified from practicing his or her profession. F, for violation of this Constitution or any other law. G, for incompetence. Or H, for bankruptcy or entering into an agreement with creditors. 2. Before removing a member of an independent institution or a holder of an independent office, the President shall notify the member or holder of the complaint against him or her for which a tribunal is being established, and B, acting on the recommendation of the Chief Justice, appoint a tribunal comprising 1. A judge of a superior court as chairperson. 2. A legal practitioner of not less than 15 years standing. And 3. One person not being a judge of a superior court or legal practitioner with not less than 15 years experience in public service affairs. 3. A tribunal that is appointed under subsection 2b shall A, regulate its own proceedings. B, inquire into the matter concerning the member of an independent institution or holder of independent office in an expeditious manner. C, accord the member or holder the opportunity to be heard and to be represented by a legal practitioner of his or her own choice. And D, prepare a report setting out its findings and making a recommendation to the President on whether or not the member or holder should be removed from office. 4. The proceedings of the tribunal under this section shall be held in camera. 5. Where the tribunal recommends the removal of the member of an independent institution or holder of independent office, the President shall remove the member or holder from office. 6. If the tribunal recommends to the President that the member of an independent institution or holder of independent office should not be removed, the member or holder shall immediately be reinstated in office. Finance. 217(1). An independent institution or holder of an independent office shall submit the annual estimates of expenditure of the institution or office to the President for presentation to the National Assembly in accordance with this Constitution. 2. The President shall cause the estimates to be placed before the National Assembly without amendment, but may attach to them his or her own comments and observations. 3. Where the National Assembly fails to approve the annual estimates and expenditure of an independent institution or office, the budget for the previous year shall continue to apply until such time that the annual estimates and expenditure for the institution or office is approved. 4. The National Assembly shall not reduce the budget estimates and expenditure of an independent institution or office below what was approved for the immediately preceding year. 5. This section shall not apply to the central bank. Reporting obligation. 218(1). An act of the National Assembly shall make provision for the submission by independent institutions and offices of annual reports to the Assembly. 2. At any time, the President or the National Assembly may require an independent institution to submit a report on a particular issue. 3. Every report required from an independent institution shall be published. Part 2. National Human Rights Commission. Composition, Functions and Powers. 219(1). The National Human Rights Commission shall comprise 5 commissioners who shall be appointed for a term of 3 years, subject to renewal for 1 more term. 2. An act of the National Assembly shall provide for the functions and powers of the National Human Rights Commission, which shall include a. To promote respect for human rights and develop a culture of human rights in the Gambia. B. To promote and protect the observance of human rights in public and private institutions. C. To monitor, investigate, and report on the observance of human rights in all spheres of life in the Gambia. D. To receive and investigate complaints about alleged abuses of human rights and take steps to secure appropriate redress where human rights have been violated. E. On its own initiative or on the basis of complaints, to investigate or research a matter in respect of human rights and make recommendations to improve the functioning of state organs. F. To act as the principal organ of the state in ensuring compliance with obligations under treaties and conventions relating to human rights. And G. To perform any other functions prescribed by an act of the National Assembly. 3. Every person has the right to complain to the Commission alleging that a right of fundamental freedom in Chapter 6 or in any other act of the National Assembly has been denied, violated, or infringed, or is threatened with contravention. Part 3. Anti-Corruption Commission. Composition, Functions, and Powers. 221. The Anti-Corruption Commission shall comprise 3 commissioners and other staff members of the Commission. 2. The chairperson of the Anti-Corruption Commission shall be appointed for a term of 5 years, and 2 other members shall be appointed for a term of 4 years each, subject to renewal for 1 more term. 3. The functions and powers of the Commission shall be provided for in an Act of the National Assembly, which shall include the following. A. To take all steps as may be necessary for the prevention, eradication, or suppression of corruption and corrupt practices. B. To carry out research on the prevention of corruption and to submit recommendations for improvement to relevant authorities regarding actions to be taken. C. To promote the values of honesty and integrity in the operations of the state and government, and to promote public awareness of the dangers of corruption. D. To investigate instances of alleged or suspected corruption referred to it by any person or authority, or which has come to its attention, whether by complaint or otherwise. E. To receive and deal with declarations of assets as may be required under this Constitution or an Act of the National Assembly. F. To investigate any matter that, in the opinion of the Commission, raises suspicion that any of the following has occurred or is about to occur. 1. Conduct constituting corruption or an economic or a related offense. And 2. Conduct liable to allow, encourage, or cause conduct constituting corruption or an economic or related offense. G. To recommend further inquiries or investigations by other investigatory bodies. H. To initiate and conduct prosecution for any act of corruption, including making referrals to the Director of Public Prosecutions for advice or prosecution. And I. To perform any other functions prescribed by an Act of the National Assembly. Part 4. The Ombudsman. Composition, Functions, and Powers. 221(1). The Ombudsperson shall comprise the Ombudsperson and 2 deputy Ombudspersons. 2. The Ombudsperson shall be appointed for a term of 5 years, and the deputy Ombudspersons shall be appointed for a term of 4 years each, subject to renewal for 1 more term. 3. An Act of the National Assembly shall define the functions and duties of the Ombudsperson, which shall include the investigation of any action taken or omitted to be taken in the exercise of an administrative function by or on behalf of A. Any department or ministry of government, B. Any statutory body or state-owned enterprise or institution of higher learning or education set up entirely or partly out of public funds, and C. Any member of the public service. 4. The Ombudsperson shall, in addition to any functions and duties outlined in an Act of the National Assembly under subsection 3, also investigate A. Any conduct in state affairs or any act or omission in public administration in any sphere of government that is alleged or suspected to be prejudicial or improper or to result in any impropriety or prejudice. And B. Complaints of abuse of power, unfair treatment, manifest injustice, or unlawful, oppressive, unfair, or unresponsive official conduct. 5. Nothing contained in this part or under any act of the National Assembly shall be construed as giving power to the Ombudsperson to investigate any matter pending before or relating to a decision of A. a court, or B. the National Human Rights Commission or Anti-Corruption Commission. Part 5. The Auditor-General and National Audit Office. The Auditor-General. 222. There shall be an Auditor-General, A. whose office shall be an office in the public service, and B. who shall hold office for a term of 9 years and shall not be eligible for reappointment. Functions of the Auditor-General. 223(1). Within 6 months after the end of each financial year, the Auditor-General shall audit and report in respect of that financial year on A. the public accounts of the Gambia, B. the accounts of all offices and authorities of the government of the Gambia, including local government authorities, C. the accounts of the National Assembly, D. the accounts of the judiciary, E. the accounts of every commission and independent institution or office established by the Constitution, F. the accounts of all statutory bodies and state-owned enterprises, G. the public debt, and H. the accounts of any other body or institution as may be required by an Act of the National Assembly. 2. The Auditor-General shall satisfy himself or herself that money charged on the Consolidated Revenue Fund or other public fund appropriated by an act of the National Assembly and expended has been applied for the purpose for which it was charged or appropriated, and that the expenditure conforms to the authority that governs it. 3. The Auditor-General may exercise such other functions as may be conferred by an act of the National Assembly. Powers of the Auditor-General 224(1). In exercise of his or her functions under this Constitution or any other law, the Auditor-General A. shall at all times carry out economy, efficiency, and effective examinations to satisfy himself or herself that public funds are spent in such manner as to reduce waste, eliminate inefficiency, and maximize the benefits to be gained from the use of resources. B. May disallow any item of expenditure which is contrary to law and to surcharge 1. The amount of any expenditure so disallowed upon the person responsible for incurring or authorizing the expenditure. 2. Any sum which has not been brought into account upon the person by whom that sum ought to have been brought into account. Or 3. The amount of any loss or deficiency upon any person by whose negligence or misconduct the loss or deficiency has been incurred. 2. A person aggrieved by any disallowance or surcharge made by the Auditor-General may appeal to the High Court. 3. The Auditor-General and any member of the National Audit Office authorized by him or her shall have power to call for and inspect all books, records, returns, reports, and other documents in the exercise of the functions conferred upon him or her by this Constitution or an act of the National Assembly, and to make such inquiries and call such witnesses who, in his or her opinion, have any responsibilities in relation to the accounts referred to in section 223(1). 4. Wherever discrepancies of a criminal or fraudulent nature are discovered during the audit of accounts, the Auditor-General shall immediately cause a report of his or her findings to be submitted to the Inspector General of Police and the Anti-Corruption Commission. 5. Where the government holds a minority interest in any company, the Auditor-General may exercise, on behalf of the government, the power to inspect the books of account of the company and report to the government. 6. Nothing in this Constitution shall preclude the Auditor-General, at the request of the head or governing body of any public body, corporation, or institution referred to in section 223(1), or on his or her own initiative, from carrying out any special audit of such body, corporation, or institution, and where he or she carries out such a special audit, it shall be reported to the Finance and Public Accounts Committee of the National Assembly. 6. Nothing in this Constitution shall preclude the Auditor-General, at the request of the head or governing body of any public body, corporation, or institution referred to in section 223(1), or on his or her own initiative, from carrying out any special audit of such body, corporation, or institution, and where he or she carries out such a special audit, it shall be reported to the Finance and Public Accounts Committee of the National Assembly. Auditor-General's Report 225(1). The Auditor-General shall a. Within 6 months of the end of the immediately preceding financial year to which each of the accounts referred to in section 223(1) relates, report to the National Assembly on the accounts and draw attention to any irregularities in the accounts audited and to any other matter which, in his or her opinion, ought to be brought to the notice of the National Assembly, and b. Publish his or her annual reports on the accounts referred to in section 223. 1. After 90 days of submission of the report to the National Assembly, or after the report has been discussed in the National Assembly, whichever is earlier. 2. The Finance and Public Accounts Committee of the National Assembly may extend the time within which the report referred to in subsection 1 shall be made to the Assembly. National Audit Office. 226. 1. The National Audit Office shall comprise the Auditor-General, 2 Deputy Auditors General, and the staff appointed by the Auditor-General. 2. The 2 Deputy Auditors General and the staff appointed by the Auditor-General shall assist the Auditor-General in the performance of his or her functions under this Constitution and any applicable act of the National Assembly. 3. The accounts of the National Audit Office shall be audited by an appropriately qualified auditor or firm of auditors appointed by the Finance and Public Accounts Committee of the National Assembly. Part 6. Central Bank of the Gambia. Central Bank. 227. 1. There is established the Central Bank of the Gambia, and the authority of the Central Bank shall vest in a board of directors comprising A. A chairperson, B. The governor of the Central Bank, and C. 3 persons not being members of the Central Bank with extensive experience in the fields of economics, finance, banking, or law. 2. The members of the board of directors shall be appointed for a term not exceeding 5 years, subject to renewal for 1 more term, and their appointments shall be made in such a way that they all do not expire at the same time. 3. The Central Bank shall be the only authority to issue currency in the Gambia, which may bear the images that depict or symbolize the Gambia or an aspect of the Gambia, but no currency shall bear the portrait of a person who is serving in public office, whether or not the office is elective. 4. The Central Bank shall be the sole banker of the government, and it shall be the principal depository bank for all funds raised for or on behalf of the government. Functions. 228. 1. The Central Bank shall A. Promote and maintain the stability of the currency of the Gambia. B. Direct, regulate and supervise the banking, monetary policy and currency system in the interest of the economic development of the Gambia and such other financial services as may be provided in an act of the National Assembly. C. Encourage and promote sustainable economic development and the efficient utilization of the resources of the Gambia through the effective and efficient operation of a banking and credit system. And D. Exercise such other functions as may be conferred on the Central Bank by an act of the National Assembly. 2. The Central Bank shall ensure that all monies paid or received for or on behalf of the government is recorded in proper books of accounts in accordance with recognized accounting standards. 3. The Central Bank shall ensure that all withdrawals from the various government accounts with the bank are properly authorized in accordance with this Constitution and any act of the National Assembly, and that the overdrawing on any of the government accounts with the bank is permitted only if so authorized by law. Part 7. Commissions of Inquiry. Commissions of Inquiry. 229. 1. Subject to subsection 3, the President may, whenever he or she deems it advisable, issue a commission appointing 1 or more commissioners. 2. The President may, in making appointments under subsection 1, authorize such commissions to inquire into A. The conduct of any public officer. B. The conduct of any district chief or alcalo. C. The conduct or management of 1. Any department or authority of the public service. 2. Any local government authority or statutory body or state-owned enterprise. And 3. Any person or entity with whom the government has entered into a contract or arrangement for the delivery of a service or performance of a duty or any other obligation whatsoever. And D. Any other matter arising in the Gambia in which an inquiry would, in the opinion of the President, be in the public interest. 3. The National Assembly may, by a resolution supported by not less than 2/3 of the Assembly, request the President to establish a commission of inquiry for any of the purposes set out in subsection 1. 4. Where the President receives a request accompanied by the resolution of the National Assembly under subsection 3, he or she shall issue a commission of inquiry in accordance with this section. 5. Except as may be ordered by the Presiding Commissioner in the interest of public morality, public safety, or public order, the proceedings of a commission of inquiry shall be held in public. 6. Notwithstanding subsection 5, the Presiding Commissioner may exclude any person from the proceedings of a commission of inquiry for the preservation of order. Presiding Commissioner. 231. A person shall not be appointed a sole commissioner or the chairperson of a commission of inquiry unless A. He or she is or has been a judge of a superior court, whether in the Gambia or outside the Gambia, or B. He or she is qualified to be appointed a judge of a superior court. 2. Where a commission of inquiry consists of more than 2 members, at least one commissioner shall be a person who has special qualifications or knowledge in the field of the matter under investigation. Function and powers of commission. 231(1). A commission of inquiry shall A. Make a full and impartial investigation into the matter in respect of which the commission is established, and B. Furnish in writing a report on the results of the inquiry, including a statement of the reasons leading to the conclusions of the commission. 2. A commission of inquiry shall have all the powers, rights, and privileges of a judge of the High Court at a trial in respect of A. Enforcing the attendance of witnesses and examining them on oath, affirmation, or otherwise. B. Compelling the production of documents. C. Issuing a commission or request for the examination of witnesses abroad. And D. Making interim orders. 3. A commissioner appointed under section 229 shall not be liable to any action or suit in respect of any matter or thing done in good faith or omitted to be done in the performance of his or her functions as a commissioner. Publication of report. 232. On receipt of the report of a commission of inquiry, A. The President shall within 6 months publish the report and his or her comments on the report, together with a statement of any action taken or the reason for not taking any action thereon. Or B. Where the President refuses to publish the report for reasons of national security or otherwise in the public interest, he or she shall within 6 months publish a statement to that effect. Adverse findings. 233(1). Where a commission of inquiry makes an adverse finding against a person, it shall, at the time of submitting its report to the President, inform the person in writing of the finding and the reasons for the finding. 2. A person against whom any adverse finding has been made may appeal against the finding to the Court of Appeal as of right, as if the finding were a judgment of the High Court. 3. On the hearing of an appeal under subsection 2, the report of the Commission of Inquiry shall be treated as if it were a judgment of the High Court. 4. An appeal under this section shall be made within 3 months of the appellant being informed of the adverse findings as provided by subsection 1, or such later time as the Court of Appeal may allow. Immunities of witnesses. 234. A witness before a commission of inquiry shall be entitled to the same immunities and privileges as if he or she were a witness in proceedings before the High Court. National Assembly to make further provision. 235. An act of the National Assembly may make further provision for the purposes of this part and subject to any such act the power conferred by any law to make rules of court for the superior courts shall be deemed to include power to make rules regulating the procedure and practice of all commissions of inquiry.